5 seconds to go. Start. He is not entitled to claim a pension under the old scheme with effect from the year 2002. Stop. The Learned Counsel further submitted that the regularization rules under which the service of respondent number 1 was regularized clearly provided that all the academic staff members who were regularized under the regularization rules will be entitled to benefit of pension only under the new pension scheme. Stop. She submitted that without challenging the regularization rules, respondent number 1 cannot claim that the old pension scheme will apply to him. Stop. The Learned Counsel asked that respondent number 1 accepted the regularization order dated 4th May 2012, which clearly provides that he can claim the benefit of only the new pension scheme. Stop. She pointed out that respondent number 1 continued to contribute to CPF throughout his employment. Stop. She submitted that it was not open for respondent number 1 to opt for the old pension scheme, as it was not open for him to exercise the option of joining the old pension scheme. Stop. The Learned Counsel asked that Rule 6 of the regularization rules has not been correctly interpreted both by the tribunal and by the High Court. Stop. She submitted that there are similarly placed 20 academic staff members of the appellant, and therefore, if the impugned judgment is upheld, the financial burden on the appellant will be of more than rupees 8 crores. Stop. The Learned Counsel appearing for respondent number 1 in reply submitted that after respondent number 1's employment was regularized, in view of clause 4 of bylaw 52 of the National Institute of Rural Development Service bylaws, for short, the said bylaws, respondent number 1 on regularization of its service was entitled to opt for old pension scheme, though earlier he had joined CPF scheme. Stop. He submitted that as interpreted by the tribunal and the High Court, Rule 6 of the regularization rules carves out an exception in the case of an employee who was initially appointed on a regular post and was holding a high academic post on a contract basis, who had subscribed either to CPF or GPF pension scheme of the appellant. Stop. The Learned Counsel appearing for respondent number 1 submitted that only 6 staff members were beneficiaries of the regularization scheme and not 20 as contended by the appellant. Stop. He pointed out that 2 associate professors employed on a contract basis, who are at serial numbers 1 and 2 in Annexure I to the regularization rules, have been given the benefit of the old pension scheme. Stop. He pointed out that as soon as the order of regularization was served to respondent number 1, he immediately made a representation disputing the correctness of the clause which provided that he will get the benefit only of the new pension scheme. Stop. He submitted that he continued to submit the representations till the year 2014. Stop. He submitted that therefore, it cannot be said that respondent number 1 had voluntarily accepted conditions imposed in the order of regularization. Stop. The Learned Counsel would submit that the tribunal and High Court have made a reasonable interpretation of the rules, and in particular, the regularization rules which calls for no interference. Stop.